Well, hi everybody. Hey, Shauna, I really appreciate the invite to Wade. I really enjoy working with the conservation district managers. I do the risk management around at Enduris, but more importantly, I really want to get you an introduction with Heather Yakeley, who you actually get her first here at Enduris. And Heather is an attorney and partner here in Spokane at a law firm called Kudik Rock. Am I saying that correct? I sure hope I.
QTAC, but it's close enough. It gets all sorts of names.
Yeah, thanks. But they're located right here in Spokane. Heather's a local. I saw that she went to Gonzaga all the way through to her Juris Doctorate degree, and we all know that that's our favorite basketball team. I think at Gonzaga, and and Heather's been doing some legal work for Enduris as a third party through her firm. Mainly in employment matters, or maybe getting into other areas of her specialization like harassment, discrimination, and ADA, which she's going to hit some of those topics today. So Heather has great experience and background in working with public entities in areas of legal and HR. And and Heather was recently appointed and hired by the Enduris Board of Directors as their internal legal advisor, and that just occurred recently. And Heather made herself available. She's been generous with her time to work with Enduris, and I wanted to get her introduced with members. This is a great forum to do that with the Wade Conference. So without further ado, I'd like to transition over to Heather and her presentation. Thank you very much, Heather.
Thanks, Joe. Appreciate that. Good afternoon, everyone. As Joe said, my name is Heather Yakeley, and I am with QTAC Rock. I'm hoping that you are seeing my screen, but I don't know which you're seeing.
I was seeing your clean slide there for a moment.
Excellent. Are you seeing it now?
Yeah.
Great. All right. Sorry, we definitely see different things from what you as the audience is seeing. So anyway, Joe is correct. I am with the law firm of QTAC Rock. QTAC Rock is actually a national platform, but we have been in Spokane for about 5 years. It's a fairly new office. I left my office that I was at for 20 years before that to come to QTAC Rock to help develop that office and also to develop the litigation group. So that's how I ended up at QTAC Rock. Seemed like a good different challenge, a little bit like becoming the general counsel for Enduris. So I'm looking forward to that, and I may meet some of you at some point in time in person. For now, this is what we'll have to do. I will apologize in advance if the dog barks. If you listen carefully, you can actually hear him snoring behind me. So again, my apologies for that, but that's still the environment. Hopefully we're getting out of that. Today, I would like to talk about ADA training. And this is a very, I don't want to say basic, this is 100,000-foot level, if you will. The ADA can be very tricky, and you'll hear me say it several times during this presentation. It's very case specific. So really one of the most important things for you as managers and supervisors is to, if you come across the ADA, you really want to make sure that you report it correctly and address it initially correctly. But then it's a great idea to contact either your manager or your supervisor, above you, so that you make sure that you get the assistance that you need. I know Enduris provides some of that assistance when they have the capacity to do it. If not, your county's legal should be able to provide you with some assistance. Or you're always obviously welcome to reach out to me. I answer questions for a variety of municipal clients, just because I know it fairly easily. So that being said, I also would appreciate questions. This is obviously an odd forum. I can't even see the 25 of you. So I believe you can either raise your hand and the moderator will will tell me there's a question or read the question, or you can send them in. The questions are great. Like I said, I'm giving 100,000-foot view, and obviously when you're doing that level, there's things that may be missed that are important to you as the audience. So the Americans with Disabilities Act is a federal statute. I'm only going to be talking about the ADA, that's the federal level, but know and understand that there is a Washington discrimination statute, which is very, very similar. It's at the state level, so it is like, for instance, a lawsuit would be in state court, not federal court, but it is very similar. And many times, if there's no case law that already exists for distinguishing or deciding a case, they'll turn to the federal law, including the EEOC. The ADA applies to those entities with 15 or more. And for the districts, generally speaking, they're considered part of the county for that counting. But there could be some of your districts that are set up differently, and that may not actually be the same. So just be aware of that as well. And again, most of what I am saying, if not everything, would also apply to the Washington level, particularly given that I'm going at the broad overview. So who is protected? The slides, because this is a different setup and I'm not there, the slides, if you are more of a visual than an auditory, they're basically what we're going to go through. Employers have to provide a reasonable accommodation to qualified individuals with a disability. Now, the one thing that you want to pay attention to or be aware of is that it cannot be a temporary disability. So here's some very easy examples. For instance, a cold or the flu, even a back strain or a sprain, which are probably more common type injuries that you see with your crews, or even a broken limb. The gray area, and of course there's always going to be one, the gray area is what is defined as a short-term illness or injury. So for instance, there's a case in federal court where the employee worked for a business where he actually had to be on site with the clients. He fell off a commuter train and he suffered some very serious injuries. He suffered some sprains and some broken bones, to the extent that he actually fractured his left leg, tore his meniscus in his left leg, fractured his right ankle, and ruptured his quadriceps in his right leg. So he actually required multiple surgeries, and he was non-weight bearing, even though it was for a sprain or a strain. He was also told that it would be, after the multiple surgeries, it would be 7 months before he would actually be able to walk normally or perform, because he had to be on site, the normal functions of his job. That would actually be considered covered. So again, that's that gray area, right? Obviously, if it's somebody saying I have a cold, no, you don't have to do anything with that. But if you have somebody who has this type of an injury, even though a full recovery is expected, you would need to provide some sort of an accommodation for that. Employers cannot discriminate against qualified individuals. So here is where in 2008, the ADA was amended. So now it is actually the amended Americans with Disabilities Act. And what that did was it took the definition. So it's an actual disability, which we can all obviously understand. That's very simple. Or it can be a perceived disability, which that's a little vague, right? What does perceived mean? So in other words, if you have, real case, if you have a person who is has suffered a stroke and they've been they've been excused to return to work from their doctor, but you as the employer are noticing that the person is having some difficulty with the tasks. For instance, if it's a clerical person, she seems to be making spelling errors that she wasn't making before. That is a perceived disability. So if you as the employer or other persons perceive an individual to be disabled, then the employer has an obligation to start the process, which we'll go through. A record of disability can also be the same type of a gray area. So in other words, record of disability, you have an individual who is insulin dependent, and you as the boss or the supervisor can't see any sort of a disability. That person is still disabled to the extent that they have certain eating requirements, they have insulin requirements, and that would be a record of a disability. So all of those now need to be accommodated, not just an actual disability that we can see. Obviously, you can't retaliate against anyone who tries to exercise their rights under the ADA. So what is a disability? Disability means very, very generally, again, a physical or mental impairment that substantially limits one or more life activities. And again, you'll see the slide references the Amendments Act of 2008. That requires a very broad interpretation of disability. And again, this definition, if you will, was broadened when in 2011, when the EEOC said that there should be a much lower standard to define it. So what is a life? Some of you are probably going, what is a major life activity? What does that even mean? Here's one. For instance, walking, talking, hearing, or learning, or even, those are all major life activities, right? You have to be able to do any of those events. Again, this is a very fact-driven analysis, and you want to make sure that you spend some time with your employee discussing what they're not able to do. So in other words, they're disabled if they can't do a basic major life activity, even when they can work. So that's where the little quirk is on that one. You also cannot, these individuals who have a limitation on one or more life activities, this is actually at all levels or all steps in the employment process. So in other words, this even includes recruiting, firing, hiring, training, job assignments, etc. Even including layoffs. So the ADA covers the entire timeline, if you will, might be the best way to put that. Oops. So what is an accommodation? An accommodation is a modification or adjustment in the work environment that is needed because of a medical condition or disability. And here's some examples. For example, a physical modification or adjustment. This can include installing a ramp, modifying a layout of a workspace. Either one of those are examples. And you'll see many times, if you go into public spaces, they'll say ADA bathroom. That simply means that bathroom is, it has the handles, it has a larger stall. That's the type of modification for physical modifications. You can also have accessible or assistive technologies that need to be modified or as a reasonable accommodation. And an example of that would be, for instance, using video phones to facilitate with deaf colleagues, or making sure that all of your computer software is accessible for a handicapped individual, whether that be a deaf individual or a a blind or a semi-sighted person. Same thing with communications. In other words, that is like providing sign language interpreters or providing materials available in Braille or large print for an employee. There's also policy modifications as an accommodation. And this is one many times, and more than likely what you would see most often. The policy modification covers basically any need to accommodate leave or attendance. So in other words, you most likely, many of you, if not all of you, have attendance policies. Well, if somebody needs time off because of their disability, or they need a flex schedule because of their disability, you have to provide that to them, and that's simply what's termed a policy modification. The examples, obviously, that are listed there are pretty straightforward. It can also include, adjusting arrival or departure time. So for instance, let's say your normal hours are from 7:30 to 4:30 or 7:30 to 4, Monday through Friday. And somebody actually just can't work at that hour. They need to work from 11 because they have appointments, or they just literally can't, they have real life example, someone that has rheumatoid arthritis just really struggles to get up and get moving in the morning before about 10 o'clock. So a reasonable accommodation was to allow this person, instead of coming in at 8:30 and working 8:30 to 5, she comes in and works from 10 to whatever that would be. Let's see, 6:30. That is a reasonable accommodation, and that is the most common normally found, some sort of granting leave or extending the policies. You'll note on number 4, it does say granting leave or extending leave beyond the company policy or the FMLA. That's a little bit, the FMLA, we're not going to touch on that today. It's its own hour topic, but that obviously grants individuals a certain amount of time off, and the ADA can run concurrent with it, but think of the ADA as running even past the FMLA. So when that 12 weeks of FMLA leave is up, you as the employer may still have to provide this reasonable accommodation under the ADA. Any questions so far? Nope. Okay.
We did have one come in. We did have one question come in, and this is that question. So is there any third-party assessment needed, or is this all observed or self-reported? And I think that's back to the disability question.
So if you, there's some that's obviously very obvious, right? If you have a deaf person apply and you hire them, then you already know what you need to do. But for the most part, yeah, it's what's called an interactive process, which we are going to talk about in a few minutes. But the employee has the obligation to say that they need a reasonable accommodation, and then the employer's responsibility kicks in. You don't have to guess at what the condition is, and if it's required, you can seek additional medical clarification. I think that might be the answer to the question, which is, yeah, you're not left to your own. You're not making a decision specifically as to whether somebody is disabled. A doctor has to provide that note and say, yes, this person is disabled. And usually the interactive process includes reaching out to the employee's medical provider and asking them what reasonable accommodation is necessary to allow them to perform the essential functions of their job. And I would normally say, I hope that answers your question, or does that answer your question? But I'll just keep going, and if it doesn't, please ask the moderator to clarify, and I'll do my best.
Perfect, Heather. Thank you.
Thanks. Okay, so here's the supervisor responsibilities, and this might also be kind of answering your question. Upon receipt, and when I say supervisor, that can be, you know, like for instance, a line manager. I know some of you vary greatly in size, and there may only be 4 or 5 of you in the office, or there may be, you know, a much larger district and have many more employees. But whoever is responsible for essentially the line employees, that's kind of what it's referring to when it says supervisor responsibilities. So immediately upon receipt of the accommodation, immediately inform and consult with your HR. If you are the HR, in other words, you're such a small department that you're it and you don't have an HR department with your counties, then I would really recommend that you reach out to your, again, I'm making an assumption, but assuming that you have legal counsel available or legal assistance available, I would reach out to that person. You know, HR is a great option, but I also understand that some of you may not have ready access to that. So you do that, and then know that the request can actually be either verbal or written by the employee. And I gave, let's see, I think I have a couple examples. Let me think here. So it's not, let's see, it's not good enough to say, for instance, my chair is uncomfortable. It is sufficient to say, I have a herniated disc and I'm having a difficult time sitting, right? That there's a big difference there. My chair is uncomfortable is not sufficient. But if somebody says, I have a herniated disc and I'm having a difficult time sitting, that triggers the supervisor's responsibility to at least explore further. And quite honestly, the best thing to just simply say is, are you asking for an accommodation? Because a lot of employees probably don't understand what an accommodation is. And so that's when your responsibility comes in to assist employees. Because again, if we go back to one of the early slides, the EEOC and the amended ADA make this a very broad statute. If you can ask the employee to put that in writing, if they're not willing to do that, make sure you document it. And I can't say this enough. My background is as a litigator, so many times I'm seeing these after a lawsuit's already been filed. And one of the biggest problems that I see by that stage is that the employer just doesn't do a good job documenting. So if you're that supervisor, if you're that manager that will continue to interface with this employee, make sure that you document it very clearly. For instance, keep a log, even if it's just a line notepad. Keep a log that says, June 15th, 2021, John came and said that he'd herniated his disc or a disc in his back, and he needs to have, I'm just going to say light duty for 6 to 8 weeks. Great. So he says that to you, June 15th, I asked John to put this in writing. June 20th, John never did provide writing, but he provided a doctor's note, right? I mean, so if you document all those, if there's a lawsuit that occurs, the lawsuit's going to be 3 years down the road, 4 years down the road by the time it actually goes forward. So the documentation definitely protects both you as a supervisor, because you could be personally named in a lawsuit, but it also protects the employer. Obviously, again, if you have HR, let HR step in and do the evaluation and make the decision. And that's why I recommend, again, either going to HR or to a legal counsel if you have it available for you. This next screen is just a couple examples of accommodation requests, and that the statute only requires that it be in plain English. So for instance, request for leave because the employee is, quote, stressed and depressed, that's enough to trigger the employer's duty. However, a few days off after a major project to rest is not sufficient. And it may be, you know, a major project that may be something tied to work. It may be tied to something else. That's where the process becomes interactive, and you do ask questions, and you have to ask questions. Let's see. The interactive process, this will allow the employer to decide whether or not there needs to be an accommodation and what that accommodation requires. Again, they don't have to ask for a specific reasonable accommodation. It's enough to say, I herniated a disc in my back and I'm not able to do, you know, whether it's clerical, I'm not able to sit 8 hours a day, or whether it's they're actually out, you know, spraying and doing that. They're not able to do that. They don't have to, at that point in time, when they bring it to the employer's attention, have a specific accommodation that they're requesting. I think I have an example. The interactive process is also, it can be triggered if you are aware of somebody who is having difficulties. That starts that process to some extent. For instance, you have an employee who has some who's mentally slow, and they deliver, well, let's see, that's probably not a very relevant. Let's say you've hired somebody who has some who's developmentally delayed, and he is mixing up letters, for instance, like on his logbook or something like that, and you suspect that that is part of his performance problem. That should be a trigger for you as a supervisor, just to clarify it, right? In other words, you're not saying we're going to reasonably accommodate you, but that should be enough to trigger your reaching out to the employee. Again, in terms of cases, case law, it's not specifically required that the employer, you know, just go running to everybody and say, hey, you seem like you're a little off the last couple of weeks. Do you need a reasonable accommodation? It's not that, and the law doesn't specifically require that. But because employees, and particularly in smaller, you know, settings, are not necessarily aware of their rights, it's always good to just check in and keep an eye on concerns if you have them.
So we did have a question come in related just to that, and the question is this: is it okay to restate your understanding of the nature of the disability and what accommodation they need, and ask for a confirmation response, such as in an email?
Yeah, yes, absolutely. So remember, and I think we might talk about that a little later on, but just remember that during this interactive process, you need to keep it as confidential as possible. So in other words, in a perfect world where you do have HR persons available, and we'll just refer to them as HR, whoever you could refer this out to. In the perfect world, you as a supervisor or a manager, you take the statement, whether it's written or verbal, and you immediately contact that person. That person, the HR person, will be responsible for communicating. And one of the reasons that person becomes responsible is because you want to keep it as confidential as possible. In other words, it shouldn't be common knowledge with other employees. It shouldn't be discussed with other employees. And so if you are that HR person, if you will, and you need to get medical documentation, again, remember that medical documentation needs to be separately stored and kept confidential. So same thing, just limit the access, if you will, to the information. In other words, other employees, sure, if you're building a ramp, everybody's going to kind of know that there's an issue, but it's not information that should be openly shared. An email is a good way to do it, and there's your paper trail. Okay, the other one, and this is a big one. I don't know if you can see my mouse. The first one: an employer sufficiently engages in an interactive process where it grants an effective accommodation, but not necessarily the accommodation requested by the employee. So that's a big one, right? I mean, that's what the interactive process is designed to do. In other words, we'll get down to a hardship burden where, in other words, the employer doesn't have to provide X, but you have to make sure that you engage in the process. And that process includes figuring out with a doctor what is necessary. And then, for instance, let's say, I'll go back to the time off thing. Let's say somebody says, hey, I need to work like 12 to 8. And the doctor says, no, you know, they don't have the ability to get up and get moving in the morning because they need to take their pills, and they need to allow those pills to take effect before they can come in. So, you know, 10 to 6. Well, the employee wants 12 to 8. That does not have to be granted by the employer, right? So it doesn't have to be the specific thing that they request. Let's say another employee, like with the herniated back, says, I need a stand-up desk. And he or she specifically wants, you know, they're really, I'm just going to give a silly example. They want the one with the treadmill. You don't have to give that to them. You only have to give them a stand-up desk. And again, that's in conjunction with medical providers. If you engage in the process fully, you will not be held liable if the employee refuses to participate, or if the employee doesn't tell you essential information. So again, let's go to the 10 to 6 thing. Let's say this employee says, no, I'm not working 10 to 6. I need to work from 12 to 8. You don't have to, as the employer, if you've done everything you can, you have the documentation from a medical provider as to what's necessary, and this person decides to quit, you can't be held liable for her or his refusal to participate. So after the interactive process is started, in that process, you should identify the essential and non-essential job tasks. And that usually starts with a job description. There may not be job descriptions. And so what I would recommend in that case is that you sit down with the employee and you write out, you know, kind of a job list that you can both agree to. And then you need to identify what they can or can't do. Again, herniated disc, person says, I can hold a stop sign for the next 6 to 8 weeks. I can't dig the ditch. I can't carry a sprayer unless it's, you know, less than 5 pounds, or I could sit on a 4-wheeler and spray, but I can't carry the big backpack sprayers. Those are just different, you know, scenarios, and that's an example of what you need to dig into. You should consult with the employee, which we've kind of already talked about, and you can do it. That's kind of answers your question in terms of letters, meetings, phone calls, and just like the screen says, always document it. I gave you the real life, you know, from my perspective as a litigator, that's the biggest downside in defending a case, is that it's just not well documented. And it may seem tedious when you're doing it. It may seem like, oh my gosh, I just want to go home and have dinner. Take that extra 10 minutes and put it down on paper. And then again, there's no right or wrong or simple answer as to a reasonable accommodation. So you just have to enter the dialogue, talk to the employee, work with the medical provider, and come up with what works, you know, and it can be more than one. It can be more than one. It could be a couple different options. Let's see, I think we already talked about that. We're gonna move on through that. All right, so the reasonable accommodations, you're going to you have to grant them. There's no option for that, unless you can prove that there would be an undue hardship. Other than that, the law requires that you provide that reasonable accommodation. The undue hardship factors. This one is, again, from the litigator's perspective, this one is the defense, if you will. But these are factors that each of you, again, if you don't have, you know, an HR resource available, should be aware of. And it's probably information that even if you do have an HR person, that they'll reach out to you on, or reach out to you to provide them with information for it. So for instance, and this differs depending on the size of the employer, which is the biggest factor, if you will. It's a very case-by-case analysis, but they look at the nature and cost of the accommodation. So, for instance, you have an individual, kind of use the example of the person who was in, you know, the very severe accident and basically had both of his legs broke. 7 months, he'll be back in 7 months, right? He can be back to walking, he'll be fine after his surgeries, etc. An option that's discussed during your interactive process is to build a ramp into the building so that he can do some light duty work. That's what he wants. He doesn't want to just sit at his house. Well, you look at the nature and the cost of that accommodation. So in other words, is it better to have him, is it more cost effective and more efficient for you as the employer to have him working in the office, and it's cost effective enough to build that ramp, or is it easier to just have him off of work for 7 months? So that's what it means. You got to look at the cost of the accommodation. You have to look at the nature of it and how disruptive it would be in terms of the impact on the operations, which is the last one down there. A big difference, right? For instance, it's going to be different for your agencies in terms of even time off. You know, you may have a critical employee who is going through leukemia treatment, and this person is going to be out for up to, you know, 18 months because it's bone marrow cancer. The analysis that you have to look at is whether or not your operations can continue with a key employee being out for 18 months. If it can't continue, do you have the budget, or can you get the funding to cover that position while he's out? And that analysis is going to be far different for, again, a district that has 4 employees plus the supervisor, or 4 employees and the supervisor, versus Amazon, right? I mean, one of the facilities for Amazon, they have tens of thousands of people and plenty of financial resources. So it is taken into consideration your size and financial structure. Now, that's what the law says. I will tell you this, again, from the litigation perspective and having defended small districts before, jurors struggle a little bit more than we would like them to make that distinction. So if it's possible, even if it creates a hardship, you want to do it if it's possible. And again, I would recommend that you don't make these decisions by yourself. You reach out to your, you know, again, your legal or an HR and get some assistance, because they are very case by case. You can look online at case law, and it's just, they're all, every single one of the cases that has to do with disability discrimination sets out a very long fact section. And in many cases that's not necessary, but these are very, very fact driven. They're driven by the interactive process. They're driven by what the employers, you know, can do in terms of reasonable accommodations.
Heather, I'm seeing a question in the chat box about an online resource. And I believe, Jean, that's your question. I don't know if you want to chime in verbally with that.
Yeah, I had a training that touched on this recently for HR stuff, and they recommended a source called Ask Jan, Job Accommodation Network. Yep. And they had a lot of good specifics, but I wasn't sure, you know, if they were more of an advocacy organization or what's your experience of them?
So Ask Jan seems to be like, for instance, here's a really great resource, literally just go to the EEOC website. I mean, it's got some really great resources, and one of their resources seems to be Ask Jan. So I don't believe that it is a government funded, you know, I don't believe it's a government program, but it does appear, because I see references to it all the time on the EEO website. I go to the website. It does appear to at least be approved, if you will, in some form or fashion. And normally, at least in my experience with Jan, it will provide you with links to, for instance, the EEOC. They have tons and tons of fact sheets, you know, and what ifs, if you will. So they have questions and then they have answers, and there's hundreds of them dealing with the EEOC. I mean, excuse me, with the ADA. So Ask Jan is a source. I think MRSC is also a resource. And then just going to the EEOC itself and the Department of Labor, you'll find a lot of helpful information, especially for this 50,000 foot view, this 100,000 foot view.
That's great.
Again, see the justification down there on the bottom, document information gathered and the steps taken to conduct analysis. I mean, probably gonna get sick of seeing that, but it is really important. This is the other one. So you can claim an undue hardship if it would be unduly disruptive to another's work site, or there's also what's called a direct threat defense. It's an undue hardship, but it actually has its own legal definition. And the direct threat defense is for those disabilities that cause a direct threat to the health and safety of individuals in the workplace. So for instance, how about you have somebody who operates your heavy machinery, and all of a sudden he develops sleep apnea. Okay, that's not something that you can accommodate unless you have another position he can go to. Another one is, how about an airline pilot? And the airline pilot develops dementia. These are not conditions which could be reasonably accommodated, and so they fall into undue hardship, but they're a very specific defense, and it has to be very distinct. In other words, it can't be speculative or remote, kind of like this first one says, can't have a negative impact on other employees' morale. So for instance, you can't say, I can't accommodate John's 18 months off because it's really going to have a negative impact on the other employees, because they're going to have to work overtime for the next 18 months to pick up his slack. That's actually not going to be, well, no, let me rephrase that, because this is always gray. That would be a very hard argument to make successfully, that is an undue hardship. Now, you can take that scenario and say, that would create an undue hardship because we receive, this employee is tied to grant money. We have to do this work or we lose the grant, right? That's different than simply saying everybody's going to have to work overtime and we can't do it. They won't be able to do the work and keep up. So again, when you are going through this process, you want to make sure, and if you're getting ready to say, we can't accommodate this, you want to make sure that you can very, very clearly articulate why you can't provide it. And a good rule of thumb, if you will, is act like you're talking to that jury, right? So for instance, you're talking to 12 people who are going to make a decision. And on that jury, you're going to have 12 people, one who's going to be very supportive of employers, one who's going to be very supportive of employees. And so when you say it, I mean, literally, sometimes I tell people, say it out loud in front of a mirror. And if you kind of go, ooh, yeah, no, that doesn't actually sound very good, or that's a weak reason and it sounds weak, then it may be that you want to reconsider that decision. So this one, I know we're getting close to being done. I want to touch on this one just really briefly because this gets complicated. The ADA, the FMLA, and even workers' compensation, it's called the tricky triangle because they tend to implicate each other and overlap each other. For instance, and this is just talking about the FMLA, but don't forget, or maybe, well, I'm assuming you're all aware of Washington State's own family and medical leave, right? There's several of them. I mean, we have a pregnancy one, we have a direct one, we have one that's similar to the FMLA. So there's lots of other rules, and you want to make sure that you are also following those. So in other words, this goes back to the example that I gave very early on, where somebody is entitled to 12 weeks of leave under the FMLA. Okay, well, just because they take their 12 weeks, or under Washington's law, you can get up to 16 weeks, just because they take their 16 weeks doesn't mean you can say, okay, well, now we can fire you. Doesn't work that way. Because the disability may still exist. And what has to be determined is whether or not the person can do the essential functions of their job with or without a reasonable accommodation. And that means, again, it's the leave of absence that usually creates the most angst for employers, because it's nebulous. It's the one that's just not well defined. So in other words, you're out of your 16 weeks, you had a complicated childbirth, whatever, doesn't matter. You're out of your 16 weeks. The employer's like, okay, this person's got to go. But under the ADA could be saying, no, 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 because time off is reasonable. And you have the doctor's note saying they only need another 16 weeks off. And then they'll be able to return to the essential functions of their job. And so the accommodation, can you perform them with or without essential, can you perform the essential functions with or without reasonable accommodation? Reasonable accommodation has been very clearly defined at every level, state and federal, as including time off. The question gets into what's a reasonable amount of time off. So just be aware that the ADA, I guess a really simple way to look at the ADA is that it can far exceed any of the other laws that you also have to deal with. It kind of covers once all the other protections have run out, right? Like for instance, under the FMLA, you can't terminate somebody when they're in that 12 weeks. Under the ADA, there's no cutoff. It's just the reasonableness factor. It's the undue burden. That's the analysis that you get into, and there's really no cutoff dates. Any questions on that? This is kind of
nothing specifically coming in yet.
Okay, let's see. I'm gonna jump down to, like I said, the ADA, the most common one is extended leaves of absence. We're gonna run out of time, but there's obviously, you don't have to provide paid leave above and beyond what non-disabled employees get. So in other words, if somebody's entitled to, they have 6 weeks of vacation built up, they get that 6 weeks. But just because they're off doesn't mean that you're continuing to, uh-oh, you don't want to see that. What just happened? Huh.
Looks like somehow we switched screens.
I don't
Screen
know
share.
what we did though. It's all right. Well, where did it go? Let's see.
Maybe if you try to reshare, you'll be able to get it back.
Huh. I don't know what happened. All right. Well,
now we see your desktop.
Yeah, well, that's probably better than seeing everything else that was up. So we'll just let me see. If I slide this over, you can see. It's just gone. Let's see.
No, I see your PowerPoint now.
There we go. Now, can you see it?
Yes.
Okay. All right. Sorry, everyone. That's just technology and me, not a good mix. Like I said, I was going to jump down because I know that we're getting close to time. Job restoration under the ADA, the employee can be granted a leave as long as it's reasonable, and then they have to be returned to the same position unless you can argue that holding the position open would cause an undue hardship. And that goes back to, we can use the same example, like for instance, let's say you have a grant employee. If that employee isn't working and doing that specific, for instance, insect collection or spray responsibility because it's grant money, that would be an undue hardship because you're going to lose that grant. So you could articulate that fairly clearly. You obviously can't penalize anyone for work missed. So in other words, they don't necessarily get to accrue their time off, but you can't take away seniority. You can't take away any of their other benefits. Let's see. This is a tough one, the intermittent leave. And again, this is one of the ones I think most employers see and struggle with the most. Intermittent leave simply means it is a reasonable accommodation. And while the ADA doesn't require complete exemption from time and attendance rules, you do have to provide somebody, with, for instance, if they have a doctor's note that says Jane can't get up due to, her medical condition until she, and function until she has her medication, which is an injection, whatever, you can't penalize that person for coming in late. However, as you'll note in this, the ADA also doesn't require that there be no requirements. So in other words, if Jane is supposed to work from 10 to 6 and Jane just is struggling to come in, right? She can't make it in at 10. She's starting to come in at 11 all the time and she's leaving early. That type of irregularity, that she's still required to follow the same policies and procedures. All right, we don't need to talk about that. I think you all know that is very hard on everybody. These are a couple examples that we've talked about a little bit in terms of the schedule. this is a true example right off of the EEOC website. The individual had asthma, needs to begin a shift. Hopefully you've all skimmed through that. They've taken time off. There's medical documentation, which says there's no way that they're to predict a flare up, but it's causing problems because the person's never online. According to the EEOC, due to the nature of the assembly line position and the consequences of not being able to plan for the absences, an employer can remove the employee from the 7 a.m. shift. So again, this is where it's important to go back to that interactive process. All right, I'm about out of time. Anybody have any questions? The rest of it was just other examples. Does anybody have any specific questions?
There were a couple of questions that came in. The first one is more general. So do you have a cheat sheet on the ADA, maybe like a basic flow chart to know how to address these situations when you don't have an HR department or legal counsel?
Do I have one? No, but I bet you I can find one, or kind of pull something together, and I can give that to Joe.
That would be great.
Yeah,
Okay.
yeah, I'm here. I'll be glad to share that, Heather. That's terrific.
And then one more question. Most of the conservation districts are at will termination. I understand making accommodations for people, but if a district wants to let someone go, what is stopping them?
That needs a reasonable accommodation, the law. So if you let somebody go that is subject to the ADA, meaning they have a disability that has been recognized as a disability, you are not allowed to terminate them absent establishing an undue hardship. So essentially these laws, and when I say these laws, ADA, FMLA, Washington Family Leave Act, all of them trump at will.
Okay. And those are the questions we've had come in so far, folks. If you do have more questions, just raise your hand. I'll unmute you or type that into the questions box. Okay, looks like we have a follow-up question maybe. Mike, go ahead.
Yeah, actually, I wasn't really asking about the Disabilities Act on that question. We've bent over backwards for Family Medical Leave Act kind of issues around our office. But it gets to the point where you feel like you're being taken advantage of on it. And not that I'd terminate somebody over that, I'd actually do more corrective actions. But it gets to the point where, I mean, quite honestly, I just get to the point where us as employers, we don't have any rights. And when we're trying to have an operation function efficiently, and we're getting hammered by the public all the time about wasting dollars and everything, there comes to be a line somewhere there. And it's so hard to find what that line is.
Yeah.
That's kind of where I was going on that.
Yeah, and that, I mean, that is the struggle. I mean, here's what I tell the employers that I work with, you know, when they come to me in terms of, hey, we've really got this problem employee, assuming that these individuals are out of their FMLA, you know, they're not covered by the FMLA anymore because they burned through it, whether intermittently or not. Like I said, the ADA may still kick in. And you have to make a business decision. I recognize that. I mean, there are some employees where you just can't keep them. And that's why the documentation becomes so important, because you want to be able to establish that you did everything you could to bend over backward for them. And in Washington, you know, you can be sued for anything, essentially, as you're all well aware. It's a pretty liberal, employee-friendly state, unfortunately. And so, while you can sue for anything. An employer wants to just make sure that they have the best defense. And that's, in reality, unfortunately, really the only thing that you can do is make sure you have a really good defense by, you went through the steps, you documented it, you know. The problem isn't, the problem in many cases, especially when you're talking about time off, is there's all these doctors that will say, yeah, John needs every other Friday off. I mean, it's kind of crazy what they can do. If you have that type of a situation where you feel like somebody is taking advantage of the FMLA, you do have rights in terms of having a second medical, like you can send them for a medical exam of your own to essentially get a second opinion. So there are some rights that you have that way, but you know, again, you can go through the process, you can follow everything correctly. You're still going to get sued, but it's going to be, at the end of the day, defensible if you follow the steps. And it's always a tough decision, because you're right, you have to balance both of those.
So that's all the questions I see coming in right now. I don't see any other hands up or questions in the box at this point.
All right. Well, good. We'll let Joe get to his presentation then.
Well, thanks so much, Heather. I know you got some things that you got to run to also. So, hey, conservation managers, you got to see Heather's debut performance on behalf of Enduris. Hey, Heather, I don't know how to give you applause. I'm just going to give you some virtual applause. I really appreciate your knowledge and what you brought. So, thanks so much, and have a great afternoon.
Everyone. All right. Thank you.
Thanks for joining us, Heather.
Thank you. Bye.
Jill, would you like me to turn the presenter mode over to you now?
Yeah, I was going to say, okay, now what? Yeah, so we're going to dumb it down a lot, that's for sure.
So you should have that functionality now to share your screen, Joe, when you're ready.
Okay, I think we're getting there. And I'm going to switch to presentation mode, and I really need a wingman here to let me know what I'm doing. Okay, so here we go. Shauna, can you see my presentation okay?
Yep, looks good. Take it away, okay. Joe.
So thanks Shauna. So yeah, Heather, she really is going to be a great resource around Enduris. She's working on a couple of really complex employment practices claims for us right now even, and she's got a great work rapport with Enduris and the leadership. So Kelly Allen, who did the talk 6 months ago, he's still around and still working at Enduris. And he's also a good resource. I think a lot of you reach out to Kelly. My presentation is going to be about interviewing and hiring and kind of all that stuff in between. I'm gonna try to set a timer here so I can keep track of time. I can't see my presentation. Okay, there we go. So if you're all managers, and I imagine you do the hiring or the interviewing, and maybe the HR if you're HR people, if you're supervisors that screen resumes and do a little interviewing, this presentation's for you. And so let's make sure this person in the business suit makes it to the other side. Okay, here we go. And that's really what I want to call the presentation, because that's where we're all kind of searching for when we're hiring somebody. They lived happily ever after, and hopefully it's with a great organization, and you want to be that great organization to match them up. First I'm going to talk about some Enduris training opportunities. Hey, I got to do this plug. And like I said on here, it's free, free. You just go on the website and sign up. Go to enduris.us, click on risk management, and go to webinars. If that's too much, just email Cindy. She's on the bottom of the slide there. Janelle is a newer trainer that we've introduced to Enduris recently, and she's a HR consultant. She's also, I believe, a professor. So, but she runs an independent firm called Aperture, and she ran her first presentation of a 3-presentation series this morning. So you missed that one. I'm sorry if you weren't there, but it was called How to Set Expectations and Goals. I attended it. She's a really good conversational talker, and she's really good at managing leadership and managing supervisors. I really enjoyed her slides about goals and expectations, and there was some good feedback too from the people that did attend. She's got 2 more presentations that you can sign up for, and they're kind of related: how to give feedback and how to receive feedback. We as supervisors, we got to have those difficult conversations from time to time. Some people like to avoid those difficult conversations. That's not always the best either. So I think Janelle will have some really good insight. And these presentations are approximately a 1 hour of investment of your time, and again, free. Heather will introduce herself to all of the Enduris membership. You guys promoted her, right? So she's going to do a topic on the diverse workplace, and that'll be in July. And again, just go to the Enduris website. And then I also want to give a quick plug to Local GovU. Hey, fire up the message box. I was kind of watching that as you went along. Get your typing fingers ready. I know it's the afternoon. You know, you got to stretch something. So get your typing fingers ready. Who's using Local GovU? Shauna, I can't see the message box, so you're just gonna have to bust in here.
That's okay. It'll take a second for folks to type, so I'll let you know what comes in.
Wake up! I need help. Who's using Local GovU? There's over 200 training opportunities there. They're all online, which is perfect for all us non-essential people like me. You know, you can tell I'm still working in my basement here, you know, hiding out. I think they're going to let me out at some point here pretty soon, really soon. So can't wait for that. I miss you guys in Leavenworth, where we ought to be. And hopefully we will be at some point soon. There's HR training.
Yeah, so far we've got we signed up but haven't used it yet. A yes, good training resource. We use Local GovU. Assignments used in the past need to start up again. So sounds like there's some familiarity out there about that resource. And funny you should mention it too, Joe. I brought up Local GovU in a different presentation yesterday. So folks, if you haven't tried it yet, you've got to go out there and check them out.
Yeah, there's a webinar linked up on how to get signed up for it off the Enduris website there. We're going to plug that a little more in the upcoming newsletter, so watch for that. But you can not only be trained as an HR person, trained as a supervisor. I've got a few examples of courses there, but you can also assign courses to your staff that check the box HR stuff, harassment and workplace type of things. They watch the video, they got to take and pass an exam, and you can track their progress. And they even get a certificate when you pass, so you have something to kind of stuff into the HR folder there, kind of like that check the box stuff. So, and if you have any questions about it, Cindy Joseph is our best resource again in the office. We pile a lot of the training stuff onto Cindy, and I'll be her backup on that stuff too. We're gonna try to utilize this resource more because I think that's just where the world's turning. There's probably, you know, while in-person meetings are great, there's probably going to be a demand for online things too. And so this is a great resource for online training. So let's get to our topic. You know, we're gonna try to clear things up a little, help take you to a better place. But I'm going to start with my disclaimer. You know, I'm not an attorney. My mission as a risk manager is to help get you to a better place. I I I don't. I'm not an attorney. I don't have formal legal training. I'm not giving legal advice. Don't rely on this presentation. It's for informational purposes only. And please consult with the attorney of your choice for your consultation needs. I haven't even stayed at a Holiday Inn Express lately. The, the, the topics we'll cover are all detail the pre-hiring process right up to the job offer. And I'm going to apologize in advance. You know, this is a PowerPoint. This virtual environment, I can't see you. I think you guys can see me. I'm not sure. I mean, half my face might be in the screen or something. I'm not sure. So you'll see a lot of slides because a lot of this is going to be just kind of me talking, and it's just not my favorite format. I like more interactive, but so I promise you it won't be 397 slides, but there's going to be a lot of slides, and don't worry about taking 397 pages of notes, like old Dilbert's talking about. You know, Shauna asks real nice. I'll be sure to share this with the Wade group, like we always do. Okay.
Sounds great, Joe. That is hilarious. Sure made me smile this afternoon.
Death by PowerPoint, or life after death after PowerPoint. Look it up. So the manager's critical issue. You know, when you have a job opening, you want to hire the right person. However, probing questions can increase your risk for bias and lawsuits. Heather talked a lot about that stuff. And the more you know about a candidate, the more you find out, there's more likely there's going to be a problematic question or a biased comment made. And then you get to the one that doesn't get the job, you know, and rejected candidates, they potentially could be hurt and angry. You see the progression here: hurt and angry people sue. They'll look for evidence you were biased, and remember, just give certain people a reason. And Enduris kind of deals in that stuff. And giving somebody a reason to sue is probably easier than you might think. A conversation about a candidate's name can get you sued. A discussion about someone's neighborhood. Hey, look at this. Hey, I see you went to North Carolina University. How cool. Were you there the same time Michael Jordan played there? You just talked about age. And it happens. You know, these are all conversational. They happen in an interview. You just have to be aware. You might assume that you don't have biases and you don't discriminate. Even the best intentioned managers get sued. And your best defense, hey, it's awareness. You got to know the traps. So we're going to talk about a lot of those things. And there you are. You got that job opening. You're looking for that perfect puzzle piece to be the perfect fit for your organization, to bring it all together and make the perfect picture. And what do we mean when we have a job opening and we say, I want the best person for the job, or I want the most qualified candidate, or I want the best fit? Maybe even some of you today have job openings, and you can kind of close your eyes and visualize the right candidate. So what do they look like? What happened in your head there? And that's where we transition to bias in the EEOC. Oh, yeah, and how many of us are getting a rush and do that? You know, don't do that. If I can have one piece of advice to you, and there's a lot of legal stuff in these slides, but it's hire slow. do that part right, and you'll have less problems going forward. So we'll talk about EEO a little bit. EEO means you can't make decisions based upon bias. And being committed to EEO is not enough. I mean, you can have an EEO statement, and I assume that all of you do. But just saying you have that commitment in black and white, someday you got to defend it. So you can't say, oh yeah, we put it on our job application, we're committed to EEO. You might have to defend it. So you have to have all of this information in your head when you're interviewing about protected groups. And so I'm going to provide you with some resources. I mean, Heather talked a little bit about, I think it was Jean that asked about an Ask Jan type of website that I've never heard before and Heather was familiar with. So I'm just going to click on MRSC. Let's see what happens here. Hey, Shauna, can you see MRSC now?
Not yet for me. There it is. Yep, there was just a slight delay. We're looking at it now.
All right, cool. No, so I'm navigating MRSC here. I just typed the word discrimination, and up pops an entire landing page from MRSC on that topic. How many of you are using MRSC just to do some light research? Just FYI stuff, or you can do deep research too. There's a lot of information in here. This page provides a general overview of state and federal discrimination laws in Washington state, including examples of local government ordinances that address discrimination based on orientation. So you have a lot of content links here that follow further down, and including resources to state law and all the things that you need to be aware of that you cannot discriminate against. Over here on the right hand side, they always have related materials. There'll be some blog articles you could read, along with maybe some links to some other things that are outside resources. There's the Ask MRSC, and they'll pick out questions and answers related to this topic, and they'll bring a few out. And then some related topics as well. Hiring procedures we'll look at later, okay? So back to the presentation. I'll give that a sec to pop back up, and moving on. EEO, you must be very cautious during interviews not to ask for information that directly or indirectly, remember the Michael Jordan playing days question, that was an indirect. Directly or indirectly elicits protected class or disability related information. You can't ask questions that can disproportionately screen out members of protected groups, only unless those inquiries can be justified by a work necessity. And we'll get into accommodation here, which Heather talked about pretty deep. Interviewers must be aware of the potential need to accommodate individuals with disabilities during the interview process. So interviewers, managers, you're all managers. Do you have other managers who aren't here that are doing interviews? Are they aware during the interview process of EEO protections and accommodations?
Yeah, we don't have all the managers, but we do have a pretty good group with us today, Joe. And we are recording the presentation. So hopefully those who are with us today can go back to their districts and their neighbor districts and recommend that those who missed this take a look at it.
Okay, cool. Thanks, Shauna. So I've got a couple of EEO resources here. And once again, MRSC, really long link, but all it was go to MRSC and type Americans with Disabilities Act, ADA. Let's link to that real quick. Well, real quick was a little bit of a misnomer. Okay, so Americans with Disabilities Act, another MRSC, this is a free research site. Overview, legal references, all the content here on ADA, the Title I, Title II, Title III, examples of policies and procedures. So you have a little bit of a, some plagiarism you can do here, right? Oh, geez, I forgot you were recording this. And then recommended resources. So again, right-hand side, some blog material and some Ask MRSC questions. And I just want to help you along with just some of these resources. And trust me, there is voluminous information here that you need to know as a hiring manager. It's daunting. Work on best practices, stay informed and up to date, and make sure you're on MRSC and you subscribe to their newsletters. And I'm not even linking to the EEOC. That thing was incredibly lengthy. That's something you can do on your own time. Now we're going to the hiring process now. And I hate to be Captain Obvious, but employment begins with the hiring process. Everybody nodding their heads so far. So I got another MRSC search here for hiring procedures. Wow, I mean they have it all here. I wish I saw this before I made my presentation. Actually, I found it kind of late in the game. But I'm gonna click over to MRSC's hiring procedures. Is this starting to look familiar? All the research you can do on MRSC. All you have to do is search and find hiring procedures. And now you have the complete bibliography of how to hire from a legal resource. So job description, advertising, affirmative action, applications, reviewing applications, interviews, references, background checks, polygraph. That one's kind of interesting. I've never been asked to take a polygraph for a job. Medical testing, use of social media, and finally resources again. And then on the right-hand side, blog articles, a couple other articles, external, some Ask MRSC questions. So is MRSC underutilized? I'm not sure. You might be nodding your head yes. You might be shaking your head no. I hope more and more of you start getting into the no column. There's a legal minefield here, and we're looking at advertising postings, job descriptions, job applications, interviewing, screening, job offer. So let's kind of hit these up one by one. Any questions or comments so far, Shauna?
Yeah, we've had a couple comments come in about MRSC. They're a great resource to search the website often. Also, MRSC has lists of interview questions, good to have on hand. And a question, what is a description or example of a protected class?
A description or example of a protected class?
Yep.
Okay. Yeah, we'll back up on the slides here. There's a list right here on this slide, and that's kind of the general list. Washington Special, they kind of have their own list, and that's why I went to the MRSC page, and it takes you to their list, including the Washington list of protected groups. Is that helping answer the question?
I think so, yes. Yep.
Great.
We got a response, yep. Excellent.
Okay, great. You guys are gonna stump me. I mean, I'll just say I don't have any special HR training. I already told you I wasn't a lawyer. I was a hiring manager for a long time before I came to Enduris. But really, my job was a sales manager, and it was with a huge insurance company, and I had an HR department. So I didn't have to think too much. I just had to get the right person for the job. So hey, it's okay if you stump me. I'm not going to answer questions and just kind of make it up. This is really important stuff. You need good advice, and that's why I'm kind of showing you some resources, some legal resources. I introduced you to a legal resource this morning, and we have a little bit of that at Enduris too. Kelly Allen has only so much bandwidth to be honest. But I know some of you have worked with him. You know, when you start getting in hot water or above your head. I'm not going to name any names today, of course, but you know, Kelly's a great resource too, especially for some of that pre-defense. He does all of our pre-defense. So let's talk about you know, help wanted. So you got a job opening. Anyone doing it this way still? Yeah, you just stick a sign in a window, have them walk in. So we're going to start with job postings. And you can kind of see a pattern here, you know, red, bad, green, good. Stick with that and you might do okay. Advertisements for job candidates should eliminate all references, whether direct or indirect, to the protected classes. Now, you also should insert an EEO statement in all job advertisements. And I'll have a couple examples later. Consider placing your job ads in media resources that will reach the largest percentage of the population in the geographic area of recruiting. So again, hey, you know, if you got anything to share, what are you using to place an ad for a job opening? How are you doing it? Is there anything special within the conservation districts that you can post a job opening and people can view that within your own industry, within your own group? I know some insurance specific ones, of course. Anything you'd like to share?
Well, I'll share a couple while folks are maybe dropping some comments in the questions box. Different places that I know of, the commission has a job posting web page, and you can send your announcements into us and we'll post them up there, as does WACD, I believe. And then if you're wanting to share that announcement on a much broader basis, NACD, the National Association, also has a job board. So depending on how far out you really want to go to recruit folks, there's a couple there. I also see an comment in the box. So there's the commission, state careers site, conservation job board, and then a question. So the job requires ability to traverse on uneven ground. Is this okay? So just a question came in there as well.
Yeah, we're gonna touch on some of those environmental conditions when you're posting, like that's the next bullet point too. Qualifications should be listed. I mean, if that's a job requirement, that can be the job description, and I'll touch on that in a little bit. The more specific you can get in your job description, the more narrow your net can be, and that's okay. So in under the right circumstances.
Great,
so
that's all the comments and questions for now.
Yeah, thanks for that question. There's more to come on that. So if any pre-employment testing or screening is utilized, like background checks, drug testing, hope you're doing some of this. You know, they should be included in the advertisement. And if there's union status, that should be included, and identify the essential job functions for that position. So once again, hey, you got to be outdoors. You got to work in rugged conditions, however you want to define that, and that may be necessary to perform the job. Okay, so I'm going to transition over to job descriptions in the job of the job opening. So here's the basics. Job descriptions. Do them right, they'll protect you. Do them wrong, prepare for a lawsuit. And when you have a job opening, start with the job description and do that before posting your opening for employment. Really review that. How many of you have detailed job descriptions for every single staff position at your district? How many of you review your job descriptions every year or more frequently as needed, like that time you have a job opening?
And yeah, let's see a show of hands. Just click the hand raise button in response to Joe's questions there.
Yeah, that's great. And how many of you review your job descriptions each year with the staff member who holds that job? So that the job can evolve over time, or somebody can start growing in their position, and maybe some other tasks they just don't do anymore because they've grown in their position, they've grown in their job. It's important to just update and revise and do those little tweaks every now and then. And it's good to review it, not just yourself as a supervisor, but with the staff member who fills the position to make sure it's still relevant. Or that can catch up to you too. How many of you have reviewed job descriptions with legal counsel for a scrub? And you don't have to do that every year, but if you've never done it, it might be a good idea.
Yeah, I don't see any hands going up in response to that one, Joe. Quite a few in response to your earlier questions, but not reviewing those job descriptions with legal counsel.
Yeah, an HR consultant can do those things too. That's another possibility. Somebody that's a specialist in HR and HR consultancy can do that type of work as well. They'll get you through best practices. Job descriptions. A good job description includes minimum qualifications, essential functions, and any unique or unusual demands. There we go again. Hey, you gotta work around uneven ground. You gotta be in the outdoors. So what does an effective job description do for you? It shrinks the pool of candidates who can sue you. And when you think about it, if your job description is really vague, it's really undetermined what the employee can and can't do as a measure of eligibility, and ultimately, if they're hired, as a measure of performance, right? So you're just kind of get stuck. You just kind of get stuck because you can't measure eligibility and performance. If you're more specific, you can shrink that pool of candidates who could sue you, and you're more likely to find that right fit. And let's say you hire somebody. Here's an example of how you can do harm after you hire based on the job description. Let's say you assign duties that aren't part of the job description to an employee. Now some people are really aspirational and they get excited when they get new responsibilities. Other people say that's not in my job description. I'm throwing the flag on you. Just remember this, and I hope you have that in there. Add that phrase, other duties as assigned, to the essential functions section of your job description. There's your kind of catch-all. And you can include other subjective job requirement information, such as in cooperation with management, or but something you want to be very specific about is physical or sensory or mental ability requirements of the job. So there's your kind of standard, must be able to lift 50 pounds, or must be able to withstand prolonged standing. And again, I'm working with conservation districts today. You're my audience. How many of your staff work outdoors in all weather conditions? If that's a job expectation, it should be in writing. And that's as long as they are job related and consistent with the business necessity. If there's environmental factors, indoor, outdoor, noise levels, include those factors in the job descriptions. Equipment, you get into using equipment from time to time. That if that's a necessary skill, it should be listed. And specific language or communication skills can be included, but only if they're required for the particular job. I mean, you might have someone in Central Washington, for example, where a Spanish-speaking individual that's bilingual can be requested. I see that a lot in job postings nowadays, anyway. so if that's a requirement for the job, you can list it that way. But it has to be a requirement. So to wrap up, job descriptions, have job descriptions for every position and review and develop them, and identify the essential functions of each job, and that will serve you well. The essential functions will reduce the pool of those generic type of candidates, the ones who will sue you. Okay, so last slide on job descriptions. Any comments, questions?
A couple. The first one you may have already covered. The question was, how does duties as assigned read legally? And I think you were just speaking about making sure to include that in the essential job functions to kind of cover that scenario.
Yeah. You can include as duties as assigned. I mean that can be necessary if you're specific is good. If you can list out specific, you're whittling down your list of generic candidates that you're going to get, because they're not going to be qualified because they're not going to meet all the specific requirements. And then the other duties is assigned in a job description just kind of says, hey, if we lose somebody or you take on more responsibility, we'll deal with it later, but you're an employee and we're going to ask you to do this too. Again, it's kind of like what Heather was talking about. There's some things that may come to greater importance than what you have written there, but that's a good safeguard and it's a catch-all, right? So
and
current.
Then one other more general question: where do you find an HR consultant? Any advice on that?
Google, yeah. There's a few like national consultancies that I'm familiar with, and anyone regional, I'm not sure. That might be an internal question for Enduris to see if Kelly's willing to refer anybody. And sometimes lawyers are a little weird that way, but if the person that asked that question wants to email me that question because they want to have some HR consultancy, I'll do some digging around.
Sounds great. I'd also ping our audience, if anyone participating this afternoon has worked with an HR consultant firm that they would recommend, just if you wouldn't mind dropping that information in the questions box, we can kick that out to all attendees.
Okay, so we're going to transfer from or move along from job descriptions to job application. So when's the last time you looked at your job application? That's kind of an interesting question. That's going to need some critical review from time to time as well. The job application is going to be the first information you really receive about a candidate in most cases. So you're looking for what? You're looking for relevant information on that application to match them with the job description. So they ought to go hand in hand. The application ought to show those qualifications. All applications need to be date stamped upon receipt because of retention records. And then this bullet point is kind of interesting about organizations that may desire to only accept applications for specific and current job openings. If you're always open and you take resumes whenever and you never close somebody's resume, or you say, hey, I'm going to keep your resume open for other future openings in 3 years, you got to go back and look at those again and see if their application is relevant to the next job opening or the next one. So if you can open close, this will help you eliminate having to review all previously received applications to determine whether or not the applicant might be qualified for the next open position. And that's kind of an area that I'm out on thin ice on. You're probably going to want to dig a little deeper on that one. Me not being an HR person, I know a lot of organizations that do things that way, and I worked for one that did it that way. I'm not sure if that's a corporate decision or a legal decision, okay? Applicants should be provided with an up-to-date job description along with the physical requirements of the job, and there should be a section of the application that should ask whether an applicant can perform the essential functions of the job with or without a reasonable accommodation. Heather touched on accommodations quite a bit. I have an MRSC link. Who is required to comply with the ADA? Let's take a look at that. So this is from an Ask MRSC research that I did on ADA. So does Title II cover a public entity's employment policies and practices? Well, it's a yes/no question. The answer is yes. Title II prohibits all public entities, regardless of the size of their workforce, from discriminating in employment against qualified individuals with disabilities, period. So it involves all of us. It's really important that we're all really up to date with that information and aware of that as we go into the job opening and job interview process. And you're even advised to provide reasonable accommodations to assist individuals with disabilities who otherwise may not be able to complete the job application process. A couple more points on the job application. Required information on an application should bear a reasonable, definable relationship to successful job performance for the position sought. So they have to have a relationship between the two. So what that means is if you're asking about eye color, take that question out, please. But you can ask about education as long as there's a certain level of education required for the position you're seeking to fill, right? And information that identifies, so check your job applications, information that identifies the applicant as having protected class characteristics, and there's a list, should be eliminated. Eliminate those questions or identifications from all job applications. Your job application should have an EEO statement, and we'll get into that on the next slide. Members with affirmative action or EEO reporting obligations, does that refer to conservation districts?
That's a great question, Joe.
Okay, well, now I'm asking questions. So there's some information that you may need to have on your job application, and that's kind of the check the box EEO type stuff. I'm a Caucasian applying for a job, and you check that box, and you know, my age is between this and this, and this is my race, this is my sex, etc. But it needs to be disclosed on that form that information shall be detached from the job application to prevent bias, and then it should also be made clear that to the applicant that provision of information is voluntary, so they don't have to fill it out if they don't want to. So here's a sample EEO.
Oh, I was just going to say, Joe, I'm not aware of any districts collecting that kind of self-reporting demographics from applicants at this point.
Okay. They may not be required. Again, things I don't know, right? So here's a sample EEO statement. We're an equal opportunity employer. All applicants will be considered for employ without attention to race, color, and all that stuff. You know, and that you're trying to identify all those protected classes that you will not be biased against. So here's another one from Dell. I just kind of stole it off the internet, right? But it's, you know, they have this statement. I'm sure they're proud of it. Dell is an equal opportunity employer, prohibits discrimination or harassment of any kind. Dell is committed to principle, and it goes on, but it kind of says the same stuff if you took the time to read it. But it's just even more specific. Dell encourages applicants of all ages, and so an EEO statement can look however you want to. It's kind of fun to Google it because there was like some web company that really had an interesting one, but it still said the same thing. It's just kind of weird in a different way, I guess. So there's no one statement there, but I think that that first one probably gets you pretty close, but always have those legally vetted, please. An at-will disclaimer should be included on all job applications. We had an at-will question earlier. Make sure you have that at-will statement. It's still important. It's not always going to be of first importance in any kind of court case because of protected classes and reasonable accommodation. But you can Google for an at-will statement. And if an application is received with a photo attached, and I started getting those as a sales manager because all the salespeople applying for jobs, they all wanted to show me that they can clean up really well and look nice in a suit and stuff, you know, so they'd stick their LinkedIn profile on there and things like that. You know, it should be immediately removed prior to processing. No bias. Applications should be signed with the certification from the applicant that, hey, what I'm providing you is true and correct, and that knowingly providing false information is grounds for immediate termination. Good disclosures. It should include a reference release form so that you can obtain more information about the applicant. And applications should be reviewed on a periodic basis to ensure compliance with new laws. Any questions or comments? Please pass them on to Shauna. I'm just gonna keep plowing here. Shauna,
we do have a couple. Yeah, we do have a couple that came in around applications. So before we leave that topic, okay. A couple of different questions actually asking nearly the same thing. So we do not currently have an application form. We ask for a cover letter, resume, and 3 references. Is an application form necessary?
Probably not if it suits you, but you're going to miss some things here. You're missing a signed certification from the applicant that all the information they're providing is true and accurate. And providing false information, which has that ever happened on a resume before, is grounds for immediate termination. And so you're missing out on things. You don't have your at-will disclaimer, maybe. That's not part of the signed document. So it could be what I'd consider leveling up. And it probably also depends on the complexity and the importance of the job too, and the impact they have on you know, the organization and some of those things. So I hope that helps a little bit. That was a mushy answer. So I'm going to go to something that I'm a little more comfortable with. That's interviewing and screening. I used to do a ton of that when I was a sales manager before Enduris. You need a bias-free questioning model when you go into a job interview, or you know, you just have a couple of notes jotted down, or are you going in there with some questions and your questions are vetted. And you should be checking your questions so they make no reference to all those protected classes. And that list is not all inclusive. You know, that's the major ones. So I want to go through a couple of bias examples. I'm going to race through these for time. We got a disability bias example. You're interviewing a blind candidate. The manager's not real confident they can read on a computer, right? So the wrong thing to say is, can a blind person do this? The right thing to say is, can you perform the functions required for this position with or without reasonable accommodation? And see what they say. So they got to demonstrate proficiency because they need a reasonable accommodation. And the candidate answers back to you that they can read using a software tool. So the right thing for the manager to say is, I ask all candidates for a role play in a work task. Will you do that? And they do that, and the demo goes well. Well, the candidate can read despite their disability, so they're not disqualified, at least not due to that. So that was an example of a reasonable accommodation. Heather talked about that. A reasonable accommodation is any change to the application, hiring process, any change to the job or the way the job's done, or the work environment that allows a person with a disability who is otherwise qualified for the job to perform the essential functions of that job and enjoy equal opportunities. Accommodations are considered reasonable if they don't create an undue hardship to the organization or a direct threat to people. So what the manager did right in this example, they never used the word disabled, they never used the word blind. They asked about behavior, knowledge, and workability. They focused on what the candidate can do, because you're looking for the right fit. And they said, I role play with all candidates. And if you say that, that better be what you do. So you better have a plan. But I like in this example how the manager said, show me how. So many interviewers say, tell me how. Show me is much more an effective demonstration of skills than tell me. So here's a list of questions you can ask, and you'll get the slide deck. I'm not going to read all these to you, but you can ask, are you disabled, or hey, do you use workers' comp a lot? How much do you use your medical benefits? You just can't ask these questions. But here's some questions you can ask. Have you ever been convicted? And we'll go to that, of a drug or alcohol felony. Do you have any documented performance problems at your last job? Because remember, the ones that are getting sign off on their job application to further check references and past employers, they can ask for that information. Doesn't mean you're going to get it, but you have permission now from the applicant. How many days were you absent from work last year? Fair question. Do you require any special work hours or time off? You know, I don't know if you've had to deal with those things. Heather had some examples there. I'm going to gender bias next. Don't ask questions about gender or related to gender. So don't ask about children to a female. Don't ask her, do you plan to have children, or oh, you know, you have children. Do you have provisions for childcare? You know, because you're worried about their work hours now. You can't ask those questions. So this happens in interviews a lot. This happened to me a lot when I was interviewing people. What happens if the candidate volunteers if they're a mother of small children? Just you can't go there. Don't talk about it. Don't focus on that. Instead, focus on the job description and say, per the job description, is there any reason you can't be here promptly at 8 a.m. each morning and available for an 8-hour shift until the end of the day at 5 p.m.? If that's what the job description requires, that's the way you phrase the question. And you know, everybody has different ways to describe that job description and the way the candidate can fit into that job description. And then there's the question, but what if you ask everybody the same questions in the interview? Isn't that fair? No, it doesn't work that way for gender. And the reason is childbearing or child rearing has traditionally been a mother's responsibility. And I'll comment, that's not me saying it. The plaintiff will steer the case this way against you. Race or origin. Avoid idle comments. So you're looking at resumes, you're interviewing, you're having that awkward moment where you just don't know how to small talk, and you say, "Oh, you have a very interesting name." Then the plaintiff's lawyer says, "Why did you focus on my client's heritage?" Now we went red and green. This one's green because that's the color of money there, people. That one can get you in trouble. Avoid comments about skin color, eye color, the way people are dressed for the jewelry. Don't ask about citizenship, origin, location of birth. Can't ask these questions. Make no reference to age in an interview. Don't make reference to age in job ads like recent college graduate wanted. That's age related. It may be indirect, but it implies. And don't make any age-related notations on a resume or cover letter. You know, I do that all the time. This presentation kind of made me pause and rethink my game, because I love taking notes on the resume when I'm interviewing. So here's a case scenario. The ideal candidate was younger and unmarried. Must be one of those types of jobs where they can progress, right? The hiring manager scribbled on a different candidate's resume when they were being interviewed. They seem older, probably over 50 years old. That was an admissible court piece. So there you go, game over. Here's another one, older candidates. An older candidate, she says she's willing to take less pay than she's ever earned before or recently. And you don't hire her, and when you let her know that, you tell her she's overqualified for the job. Is that lawful? Let's hear it. Is that lawful? Yes or no?
My initial reaction, Joe, was crash and burn. If my calibration is correct on that.
Well, you get applicants where somebody's overqualified for the job. I'd see those all the time. I'm like, oh man, they're way above the qualifications for this job. Why are they even applying for this? And can you tell someone I'm not hiring you because you're overqualified for the job? Is that lawful? The answer is probably.
What do others think?
Probably not, unless you can demonstrate why the younger candidate was better, and that's a challenge. So you got to look for factors on why you're not hiring. That's why the job description needs to be so specific. Comments like we're looking for new college grads, or we think a person with less experience will fit in better, that they're going to get you in trouble. So watch comments, stick to the job description and qualifications. Convictions and arrests. Background checks are okay and encouraged. And you can ask whether a candidate's been convicted of a crime that's probably on your job application. But unlike convictions, arrests are not conclusive evidence of wrongdoing, so you can't ask about that. You can never ask, have you ever been arrested? One exception, if you're a law enforcement agency, nobody here, if you're a agency like a school, or you have supervision or responsibility for minors or vulnerable people, you're allowed to check. But that's the only really exception to that. I'm gonna speed through some interview ideas. How are we doing on time? A couple minutes, right?
Yeah, just a couple minutes. This is the last regular session of the day. So if folks want to hang around, if you're willing to stay on for a while longer, Joe, and ask questions, I'm perfectly okay with that as well.
No, my time's yours, but to be respectful of your time, I'll try to speed through this, and you'll get the deck, but I've got a few comments in here too that I hope you can pick up on. I want to talk about some interviewing ideas, and this is the part where I really wish we were in the same room interacting. So again, interviewers, you want to be as thorough as possible as you're screening candidates, and you got to dig, but digging increases risk. So focus on non-discriminatory issues: behavior, knowledge, ability. And here's a big one. Interviewers need to be aware of the potential liability for negligently hiring an employee who later causes foreseeable harm to others. So do your background checks, do your reference checks, take notes, and do all your due diligence on that candidate's background. That foreseeable harm thing, that has happened before, not in Enduris as far as I know. How do you guys screen a resume? You get a block of resumes. Do you screen it as the hiring manager? Do you have other people look at it? And what are you looking for when you look at a resume and a job application? Do the candidate's qualifications match the job description? And screening is really important prior to the first interview. Once you open that door, they're kind of in, and you're talking. They're hopeful they get the job, right? You're kind of upping the ante every time. So the screening process is really important. Here's some resume red flags. You've probably seen these before. I'm not going to go through them all, but when you see these things in a resume, these throw up red flags, and I'm not going to say they're disqualifiers. You don't throw away someone's resume because they didn't use the right term of their properly in the English context, but some things will raise red flags, and if you're gonna bring them forward and interview them, et cetera, and they have some of these gaps here, you want to raise scrutiny on those details if you continue forward with the candidate, because there's some flaws. So make sure, prior to the job description, prior to the job interview, or at least at the job interview, they're presented the job description. I like show me, not tell me. Show me is a demonstrated skill, a role play. Tell me, boy, who's been in an interview and been bamboozled? I had to interview salespeople. That was an art. I interviewed a lot of people who could talk a good game. And I actually hired somebody that was all talk and no walk. I mean, everybody loved this candidate, and they aced the aptitude test, but they couldn't do the job. You gotta find demonstrated skills on the show me. Think of ways to qualify those skills. As a sales manager, I did a role play with candidates kind of later in my time as a manager. Everybody could say they could do the job and sell, but in the interview, at some random point, I'd write down my phone number, my cell phone. I'd slide it across the desk. I'd tell them, okay, pretend you're the hired sales rep, and I'm the prospect. I want you to walk out of the room and close the door. Call me in 2 minutes, no later, and give me your sales pitch. That's all. No instructions. The people with the plan and with natural skills and a clear head, they could do it. And this was very, very challenging. But it was completely relevant to the job. And you can do that too, as it fits your job requirements. In sales, it was a fly or die job. I gave them a fly or die assignment, and boy, you could watch people that could talk a good game crash and burn, or maybe they pulled through and wow, they did a great job, and you knew they were going to nail the job. Demonstrated skills, show me. And have you heard of this one, the mirror effect? Selecting people you like works great for friends, but not always the best for your organization. Okay, so watch out for only looking for candidates that act or have your profile or look like you, or have your career. Just kind of be self-aware of the mirror effect. This was going to be interactive. What's what's the right number of interviews? A basic position might be able to be handled just in one interview, right? My teenage son, he's applying for a job right now, concessions runner with the Spokane Indians. He threw in his application. I imagine he'll get a phone call, and he's either going to get a phone call interview or an in-person. And that's it. He's going to get the job or he's not. Wish him luck. He really needs a job. But a high profile position, let's say you're hiring an upper level manager or an executive director or something like that, recruitment could take multiple interviews and last weeks or even months. So I'll describe to you my process a little bit, just kind of generically. It's screen the resumes, qualify candidates for the phone interview, face-to-face, number one, then an aptitude test if they're promoted again, and then if they make that cut, face-to-face number two is a finalist, and then I make a decision, hire or pass. I want to see these people and hear from them 2 or 3 times, and twice in person, because sometimes they can talk a good game in one interview, but then they tell the same stories in the next interview, and you kind of know, well, they're a little thin on their experience, or a little thin on their stories. They keep telling the same stories. I once had a candidate that was, anyway, So what's the right number of interviews? It depends. So I'm going to talk about the phone interview and then the one-on-one. It's just a progression, right? I like the phone interview to be a basic screening before I invest the time for face-to-face. Just talking and listening skills, talking and listening skills. My questions are more general. Everybody gets these questions when they do the phone interview. I'm just kind of checking them on their information they provided me in black and white to see if they can talk about these things. If they can't answer the questions well, you might consider moving along. These questions are kind of simpler than the progressive interviews. But I always ask a couple of questions that are in those bullet points. What did you do to prepare yourself for today's interview? Because I want to hear what their plan is. And then I also want to hear their research for this job, because that's an indication of how bad they want it. Tell me what you know about us, and see if they went on our website and learned a little bit about us, Googled us, etc. It might show an inquisitive mind or a thinker. These might be soft skills you're looking for. So here's a few do's and don'ts. Do check for soft skills. That's that emotional IQ, listening, interacting. Don't focus on the resume and nothing else. That's the hard skills. People get hired for their hard skills and their resume, and then they wear out their welcome for their lack of soft skills. And the soft skills mean, the lack of soft skills. They can't get along. They're short-tempered. They have a bad attitude. And so focus on the do's. Probe how they react to situations. Add stress points. That's called behavioral interviewing. Role play where applicable. Think about how you can do that. Don't give away all the answers. That one's kind of interesting. I've been in some interviews where the manager likes to tell how we do it and then ask, what do you think about that? And if somebody wants the job, they're going to say, I think that's great. Yeah, I can do that. No, ask them a constructive, critical thinking type of a question that's bent towards the behavior that you want, and see if they can answer it correctly. It's hard to retrain people from bad attitudes or short tempers, and once they're on the staff, they're kind of hard to get rid of. Hire slow. And do you feel pressure to make an offer after interviewing the existing candidates? Time's running out. You have a job opening. People are doing two jobs at once sometimes. Take your time. I had a position open in Alaska for about a year once. We kept getting candidates, but not the ones with the right qualifications, and we got pretty far, and I just never felt good about making the job offer, and so ultimately after about a year we got the right candidate, and I knew that because after his first year he was the corporate salesman of the year. 2 years later he was the corporate sales representative of the year. So where's the failure in waiting for the right candidate to fill the position? Take your time. Probe a little bit. Do you get fluff answers? Nothing burgers? Probe with behavioral questions. Look for their reaction to stress in the interview. Ask performance questions and motivation questions. So I'm just kind of wrapping up my slides here. Sean, are we okay?
Yeah, we've had a few people wander off who maybe have had other engagements, but still have a group with us. So
yeah, okay.
I would say go ahead and wrap up, Joe.
Okay, so behavioral interview question ideas, stress points, and these are just interview questions that I usually ask, and they come up in interview 1, 2, or 3. So first you ask them about how they react to job stress. Describe a time when you disagreed with your boss and how you handled that situation. You're gonna have to work with that person. Tell me about a time at work when you had to deliver bad news. That might be about having a positive attitude and how they deal with stress. The emotional IQ. Tell me about a time when you were overloaded with responsibilities and how you prioritize the work. And overcoming rejection is the last one. You can ask performance-related questions. Tell me about a situation when you outperformed your peers. Describe a time when you positively impacted the bottom line. If they're having trouble answering these questions and you really want someone to have an impact in your organization, it's kind of time to move along if you're getting those nothing burgers, because you don't have to eat those. Describe a time you made a difference for your organization. Give me an example of work goals you set for yourself and how you went about meeting them. And I always throw work in there because I want to keep it on work. I don't want to hear their personal stories about their personal goals. I always throw the word work in there because I want to keep it on topic. Behavioral interviewing about motivation. And I want motivated employees. I don't know about you. So I'm going to ask them motivational questions, and they better knock it out of the park. What motivates you to come to work every day? What are the 3 attributes of a good employee? You get some interesting answers on that one. Do you self-evaluate your performance? And then the final one, really important for this job. What makes you believe you can do this job? What makes you believe you can do this work? What makes you believe you can, and you fill in the blank in your question that's job related to whether they succeed or fail. And you listen to them. Make sure they've really thought about that job. So the job offer, just make sure you have a job offer that's in writing and that it's vetted by HR. And don't make promises in the interview that you're not going to find in the written job offer. Oh yeah, I don't mind if you show up late for work, and that's okay. We don't really monitor that. And then the written job offer says, hey, you got to show up promptly at 8 a.m. Be careful with your conversations. So develop that standardized letter and get a sign off. And then they lived happily ever after. So sorry to go a little long, but Shauna and everybody at the regional managers, the managers, thanks for inviting us, Enduris, to Wade. It's a real pleasure to partner with you. I was looking at the guest list earlier, the attendee list. I work with so many of you, and I'm glad you do reach out to us and you attend these seminars. Look for the training that I alluded to earlier, and just email me or call me after the presentation sometime or sometime this week. Give me a call if you have any follow-up. Thank you very much. Shauna, I'm gonna give this back to you.
Thank you so much, Joe, and thank you for bringing Heather and having her debut with us here this afternoon too. I know she had to move on to another appointment, so please thank her for us. I do see some thank yous and great presentation, great references coming in the comments box, so that's awesome. And we will be posting Joe's slide deck and Heather's slide deck, along with the recording of the presentation today, up on the Wade website. I think the goal is to get everything up there by the end of next week. So if you happen to miss a key piece here, or you weren't jotting down notes fast enough, that's okay. We're going to get those materials posted up there for you to reference again. So